Hey, so in this video, we're going to talk about how to keep the farm, the property, the land in the family. So I'm Paul Rabelais. I'm an estate planning attorney and really work out of our offices around Louisiana. But some people who live in Louisiana, they have what they consider to be really valuable property. Maybe it's valuable from a fair market value standpoint. Maybe it has a lot of sentimental value to the family. And that property might be in Louisiana or it might be in any other state. And for one reason or another, I'll call them the parents who have children and grandchildren, the parents want to keep that property in the family. Maybe they've seen the children and grandchildren enjoy the property, hunting, fishing, just family spending time together, four-wheeler, whatever. And they really don't want to see, even after they pass away, they don't want that property to be sold. They want the children and grandchildren to be able to enjoy it. So what are the best ways to do that? And I'll warn you, every family is different, every set of circumstances is different, but there's some kind of common themes that we have in our discussions with clients who have that as a goal. So we have to start really with, what if there is no kind of formal plan in place to keep the property in the family for generations? And by generations, I mean most parents feel like, they've seen their children and they've seen their grandchildren enjoy the property. So they're thinking they want to keep it at least in the family through the next two generations. Maybe they don't even have great-grandchildren yet, but if they did, they may want to keep it in the family so that they could enjoy it as well. But going back to what some of the rules are, because you really need to understand our property rules that we have, at least in Louisiana, when multiple parties own a piece of property, which is common. And let's say the parents have three children and 8 grandchildren. And so the typical scenario is parents pass away and they leave that, I'll call it the farm, to the 3 children. Well, a lot of parents think that, in corporations and in elections, majority wins. So if 51% want to do something, they got to do it. They can do it. Not the case with property and co-owners. We have a rule in Louisiana that says no one can be compelled to hold property with another in indivision. And when the 3 children own that property, it's called they own it in indivision. Some children come in and let's say mom and dad had a 90-acre tract, and a child comes in and says, I got 30 acres. My parents had 90 acres. They left it to us 3. I got 30, and my brother and sister each have 30. Well, technically that's not right. They each have a 1/3 undivided interest in the 90 acres. So we have a rule: nobody can be compelled to own property with another, and so any co-owner could sell their ownership interest to a third party. And then if they really want to cash out or cause problems, even a 1% owner, they can really force a sale of the property through what's called a partition. And there's 2 kinds of partition. There's a partition in kind where the co-owners go through and the property is susceptible to be divided into lots of equal value. So sometimes there's a kind of forced situation where the 90 acres is divided into 3 30-acre tracts, perhaps, and each child gets their own tract. But when that's not susceptible, then there's likely to be a partition by licitation, which is a forced sale of the entire piece of property, and the proceeds are distributed to the co-owners in proportion to their ownership interest in the property. So even if someone's just a 1% owner, they can force that partition. That'll ensure that the property is not going to stay in the family for generations. Or perhaps a co-owner has a creditor issue, IRS issue, child support, whatever. And so then a creditor could take that child's interest in the property. So there's lots of potential problems out there. Some people think they can solve the problem by forming what's called an LLC, or a limited liability company. And many farm owners, landowners should consider forming an LLC, but that's more so for protecting the owners from lawsuits and from losing everything else they own if there's some liability as a result of having an ownership interest in the property. So the LLC, limited liability company, is really more for liability protection than for a mechanism to keep the property in the family for generations. If mom and dad own an LLC, they leave it to their 3 kids. Each has a 1/3 interest in the LLC. Any one of those owners can sell their interest to another party. A creditor could seize their interest, and lots of the same problems surface. Okay, so what oftentimes the conversation often leads to parents owning property or owning an LLC which owns the property, and they transfer that property or the LLC to a trust to try to keep it in the family for generations. That trust can last for many, many years. They can name a trustee or co-trustees of that trust after the parents pass away. Maybe the responsible child, or the one who really wants to keep the property in the family and has the same philosophy as the parents, would be named as the trustee to manage all of that property for the benefit of all of the children and grandchildren, ensuring that the property stays in the family, perhaps for at least 2 generations. And 2 generations, maybe grandparents have, grandchildren who are 10 years old. If they can ensure that the property stays in the family for 2 generations, it may stay in the family for at least 70 or 80 years. So the parents name a trustee that provides for the proper management of the property. That trust is likely to be a spendthrift trust, which means that none of the beneficiaries of the trust, none of the children, none of the grandchildren can sell, mortgage, or alienate their interest in the trust. If a descendant gets sued, a creditor of the descendant can't seize that descendant's interest in the trust. So now we're talking and having a conversation about making sure that the property doesn't go anywhere and that it's managed properly and everybody can enjoy it. And again, we'd have to structure all of that correctly. A few of the things that we're not considering in this video, but may need to be considered when wealthier folks have farms that they want to pass on down for generations. There's a worry, or could be a worry, about the estate and gift tax. It's not a worry for most because at the time I'm making this video, 2019, the estate tax exemption amount is $11.4 million. If you have a married couple, they get to double that, so it's $22.8 million that couples can leave to their heirs without having to worry about the 40% estate tax. Another issue that we're really not addressing, or you may actually want to consider, is when you leave property or an LLC that owns property to a trust like this, if it's not producing significant revenue, you may want to address leaving funds some of your funds to that trust to cover property taxes, maintenance, insurance, and all those ongoing expenses, so that none of the beneficiaries will have to cough up money just to cover ongoing expenses of the farm or of the property. So you may want to consider not only leaving the farm in a trust, but also adding some funds to that as well. And then another issue is really on the polar opposite of the estate and gift tax issue, is the set it up right so that there's not a forced sale if there's a nursing home issue. So really wealthy people don't worry about this, but middle class people do, is want to set it up the right way so that if the parents need to go into a nursing home, there's not a forced sale of that farm property that would be required in order to pay the parents' nursing home expenses. So again, done the right way, you can make sure you protect yourself from that. And then you also may want to consider, a lot of parents like the thought of, well, if this trust is going to be in existence for many, many years, let's set it up now. Let's create that trust that we can change and we can revoke while we're alive if we want to change something. But it becomes irrevocable when we die, and then the farm doesn't go through any kind of probate because things in a trust don't have to go through that. So that's another issue that likely would need to be discussed when all of this is getting set up. So bottom line is you probably only have one shot to get it right, and you got to get it right the first time, because the decisions that you make and the plan that you put in place could affect your family for generations to come, 2, 3, 4 generations to come. Making a mistake really can mess things up, and in some cases just destroy, family relationships. So make sure you get it right. Good luck with it. And make sure that you subscribe to our YouTube channel so that we can keep, providing you valuable information. If you felt like, this is providing you some value, hitting that thumbs up would be great. Feel free to share, some valuable commentary in the comments below, and make sure you take care of your business. You've earned it. Now you got to keep it. See ya.